Hey everybody, John Skiba here. I'd like to welcome you to tonight's live stream. It's Thursday night. We do this every Thursday night. And for those of you who may be joining us now or maybe watching the replay of this, welcome to you as well. But I'm a consumer protection attorney in the state of Arizona. I deal with people who are being sued by debt collectors. I represent them as well as typically Chapter 7 and Chapter 13 bankruptcies. So each Thursday evening, I like to do a live stream, go over some questions that you may have. There's always a ton of comments on the videos that I put out. And frankly, I don't have time to be able to get to them. So as we get started tonight, generally how I do this is if you have questions you want to talk about related to debt collection lawsuits, bankruptcy, wage garnishments, all those types of awful things, I'm happy to discuss them. My caveat every week is that I can't give legal advice. I am a licensed attorney, but only in the state of Arizona. And so I don't know all the statutes. I don't know the case law in each and every state. And not only that, but we've never met. So I don't know the specifics of your case. So anything that we talk about tonight is just information to kind of give you maybe a starting point to do your own research and dive into that. If you do have a question, go ahead and put it in the live chat. What I'll do is I take some of those questions and I'll put them up on the screen so that everybody can see them. So if you're not comfortable with your question or your name being on the screen, please don't put it in there. But I'm happy to go over some of those questions that are posted there. To get started tonight, I thought I would give you a couple of resources. I actually did a video on this a little while ago. But if you're representing yourself in a debt collection lawsuit, in most jurisdictions, the courts are required they hold you to the same standards they do lawyers. And not only that, if you're drafting motions or an answer, you may have questions about the rules of civil procedure, about case law in your state. And so you may wonder, where do you even find this stuff? I know it's so weird to think that there's all this law, but who controls it? How is it put out there so that we can access it? Well, there are a couple of free resources that you can use. One is our friends over at Google. Or if you go to scholar.google, Google Scholar is what it's called, but it's scholar.google.com. They actually allow you to search the legal decisions in your particular state. You can toggle, there's a little button that says, you click on, it says case law, and you can choose the state that you want to get the information on, and you can put topics. And often what I recommend is if you're being sued by like a junk debt buyer, you go and you plug in there Midland funding, portfolio recovery, and kind of see the cases that come up, because you're going to see a lot of the common elements in your case show up in those. And the reason is because the debt buyers' lawsuits are the same things over and over and over. It's just forms over and over and over that they use. The arguments are very similar. So that's a good resource. There's also at Cornell Law School, they put out a great website called the Legal Information Institute. The website is law.cornell.edu, and it pops up and it has access to the federal rules of civil procedure, rules of evidence. They have it for each state. It's just a great resource if you're looking for something, particularly with the rules and statute base. It's going to be in there, and they can help you with the the battle that you got going on. So, all right. With that being said, let's go ahead and jump into some of the questions. Got a question here from Dave. Says he has a 341 meeting, March 17th. Discharge should be soon, right? So some background, if you're filing for bankruptcy, whether it's Chapter 7 or Chapter 13, after the bankruptcy case is filed with the court, about a month to 5 weeks later, they're going to hold what's called the meeting of the creditors. The shorthand for it is called the 341 meeting. 341 is the code section in the bankruptcy code that authorizes these meetings. And so once you have the meeting of creditors, and generally it's a fairly short meeting, it's usually about 5-10 minutes. They put you under oath and ask you some pretty generic questions. They may have questions about some of your assets, those types of things that they may go into that there. Once that's over, usually your discharge is entered about 60 to 90 days later, assuming that there's no other issues or problems that the trustee needs to dig into. Excuse me. Meeting of creditors, if your 341 meeting is on March 17th, you're probably going to get the discharge sometime around May 17th, could be as late as June 17th. Just depends on when the trustee does their part, pushes it through to the clerk. And when your paperwork comes to the top of the pile, they'll push the discharge through. So it should be coming through pretty soon. And Dave, thank you for that. Again, we have the super chat. I talked about this last week. I didn't even know these things existed until now. Appreciate that. I use the funds that you have provided to help support the channel. There's a lot of kind of software and things going on. So I really appreciate it and appreciate you supporting the channel. All right. Hey, Muriel, you're here every week, and I appreciate that. All right, let's talk about this question here. Post-bankruptcy Chapter 7, how long does it take for your score to increase? My score did dip right after the information appeared public. This is a great question, and I actually did a video on this recently because I've been doing a little more research into the impacts of bankruptcy on credit score. I've talked to clients over the years. I've talked to mortgage lenders to kind of try to determine when the score increases. And truthfully, the credit score itself, a lot of it will depend, first of all, where you're starting. If you're starting with a higher credit score, 680 to 750, something like that, you file bankruptcy, you're going to see a significant drop. You're probably going to see a 100-point drop. And it may even take it a little bit longer to bump up. But if you're already fairly low, if you're low 600s, if you're below 600, below 500, you're actually going to see an increase fairly soon. Usually I tell my clients to look 60 days after the discharge order is entered and kind of see what their credit score is then. I mean, the bankruptcy is going to show up in the public records part of the credit report, and that'll stay there for 10 years. But your score itself will probably go up dramatically. Could even go up 100 points or more, even within that first 60 days. The reason why is because you are eliminating the things that are causing your credit score to be low. Credit scores, they look at your on-time payments. They look at accounts that are delinquent. They look at the amount of credit that you're using, as compared to how much credit you have. Well, the bankruptcy, what your credit score looks like, or your credit report looks like after you file for a Chapter 7, is that actually the accounts are still there, but they're all zeroed out. And then they'll have a notation in there that says they're discharged in bankruptcy. So you're eliminating all of that debt. So your debt to income ratios are not off anymore. It stops them reporting debts as delinquent. So you do have the bankruptcy on there, but most people see the score go up pretty considerably. I can tell you that in talking to mortgage lenders, if you're trying to get a home loan, FHA, they will do mortgages usually 2 years after a Chapter 7 bankruptcy filing. Other lenders, it's about 3 to 4. You kind of have to shop it around a bit. Car loans and credit cards, they're available almost immediately for good or for bad. You're usually just not going to have good interest rates until you get a little bit further away from the bankruptcy filing. So hopefully that helps out there. All right, let's see. Laura has a question. Laura, thank you for joining us on the live stream. It says you're filling out the answer form for California. At the end, there's a section that says defendant praise. Any for recommendations for what to say there? This is a good question. Again, my little caveat, I'm not licensed in the state of Arizona, but something like this is pretty generic from state to state. And part of it is just the legalese that lawyers have used over the years. The end of the complaint or the end of the answer, sometimes it's called a prayer for relief. And you'll see it in the complaint or the petition that the creditor files. Their prayer for relief usually asks for a specific dollar amount as far as what they're wanting, or if they're wanting attorney's fees or court costs, it'll all be included in there. Your prayer for relief is you're asking what the court wants to know. Is there anything specific you're asking for? So you've gone through and responded to the allegations of the complaint. I always ask in my prayer for relief for my clients here in Arizona, I always ask for reimbursement of court costs, like the filing fee, and for attorney's fees. If you don't have an attorney, if you're representing yourself, you can't ask for legal fees, but you can ask for reimbursement of your court costs in the event that you prevail. So the prayer is really all that they're just saying. Basically, what are you asking for here? Is are you wanting the case to be dismissed? Sometimes I'll throw that in there as well. It's not going to be dismissed just because you put it in there. But sometimes I'll say that the defendant, requests that the lawsuit be dismissed and that they be awarded their costs and attorney's fees. So that's one way to just kind of let them know exactly what it is that you're doing there. So, all right, let me see what else we have going on here. All right, this question here, credit reporting question. Paid off a collection for $2,300 from Synchrony Bank in mid-March. Does it take a while to remove it off of my credit report? So there's kind of two things that are going on here. When you pay off the collection, I should say this, anytime you do something on a credit report, generally I say it takes at least one cycle. Roughly every 30 days, the credit reporting agencies, Experian, TransUnion, Equifax, they're updating their records to show that the new information that's come in. However, with something like this, while it'll take it out of active collections and out of a delinquent or derogatory state, it's unlikely that the whole thing will just be deleted unless that was something that you agreed to. If it was something where you contacted Synchrony Bank or whoever was holding it and said, hey, I'll pay this off, but I need to delete it, and they agreed to, then it will actually go away. But if it's something where you just paid it to zero it out, the account will still be there, and negative information stays on there for approximately 7 years. So it won't show up as derogatory. Your credit score will be improved, particularly as far as how much it'll improve. It depends on how old the account is, if it was newer or if it's been on there for a while. But you will see a bump up. It just kind of depends on how much that'll be. All right. Let's look at this one. I just got a default judgment even after I filed a motion to do arbitration. It was on time and they just ignored my motion. What can I do now? It's tough to say without knowing some of the specifics as far as what state, but the question, default judgments are usually only filed in a couple of situations. One is if you don't file to the initial complaint. You get served with the summons and the complaint or the petition, and you usually have a specific time period to respond to it. If you don't respond in that specific time, then they can enter a default judgment against you. So the question would be, is if you filed a motion to compel arbitration instead of an answer, was that motion timely? If it was, then you can go back in and file a motion to vacate the default judgment that was entered and point out, look, you're going to have to show evidence. The burden is then on you to show evidence that you did file a responsive pleading or response to the complaint on time and that the court made a mistake. Courts do make mistakes. I see it all the time. And so it may be sometimes, particularly if you file your answer or your motion right about when it's due, sometimes, right hand doesn't know what left hand is doing, and they just push it for a default, even though your motion was sitting there. So that's something you want to find out, is make sure that everything was filed timely. And then if it was, then you need to look at filing a motion to vacate that. All right. Let's take a look at this one. This collection reported that the debt they've been trying to collect to the credit agencies, they did not tell them it's being disputed, and TransUnion's refusing to take it off the report. What can be done there? If there's something on your credit report and you've disputed it, and I should say this. So there's this law called the Fair Credit Reporting Act, the FCRA. The Fair Credit Reporting Act is essentially the rules that you have when it comes to how things are reported, as far as what the credit reporting agencies are putting out there and what providers, things like collection agencies, general creditors, the information that's going on your credit report. It does provide for some remedies. If there's information on there that's not accurate, you can actually even sue them to get that corrected. A prerequisite of that, though, is that you generally have to go through and submit a dispute first. And so if you've done that, which it sounds like you have, I guess I should say this. There's a difference between just saying that the debt's disputed and actually filing a formal dispute through the credit reporting agency, whether it be through their online system or actually sending in a physical letter stating that you dispute it. If you do that, then the creditor has 30 days to respond to it to determine if to provide information to verify the debt and provide support for why it should be on your credit report. If they don't respond, the credit reporting agency, the credit bureau, is required to remove it at that point. If there is information that's provided, but they believe that there's enough there to support it, then you'll see that it will show up on your credit report as disputed. There may even be a notation saying that the consumer disputes the accuracy of the information, but the creditor has verified it, something like that. If you still believe that that's incorrect, that's when you may have to actually look at filing a complaint, a lawsuit under the FCRA. My recommendation is you find an attorney that deals with Fair Credit Reporting Act litigation. There's generally an attorney's fees provision in there. So often they'll take those cases on a contingency. And if it's a good case, they can help you to get that done, get the credit cleaned up, and they may even get you some damages on top of it. So, all right, let's see what else we got here. This question are there any new laws coming out that would benefit consumers against debt collectors or creditors? It's an interesting question. And the issue is that most collection laws, I mean, there's the Fair Debt Collection Practices Act, the FDCPA, which has been recently updated. I talked about that in a video that they actually, that federal law, they've actually updated that. I feel like to make it a little bit, some parts of it are worse because they're going to allow debt collectors to contact people through social media platforms. So you might, if you're on Facebook, you might start getting, messaged, or on Twitter, direct messages from debt collectors. That goes into effect, I believe, in November of 2021. So later on this year. But most debt collection laws, it's very state specific because they bring those lawsuits into state court. And so it's state law that they're applying. Like in Arizona, where I live, it's much more difficult to object to like certain documents as hearsay because the court follows this incorporation doctrine, which I don't agree with, but they follow it here, and very few other states do. So there's other states that are out there where these kind of cases are handled completely different. So it's tough to say on the state level because I don't know. But the federal law, the only change I've seen is in the FDCPA laws that are changing. There's constantly discussions of the bankruptcy code being changed to allow student loans to be discharged. Kind of a funny story on that. When I was in law school, I graduated from law school in 2003. In 2002, my bankruptcy professor was a guy named Bruce Markell. He's actually one of the drafters of the bankruptcy code. He assisted with that. He also assisted with a book called Collier's on Bankruptcy. So he's literally one of these guys. He wrote the book literally on this. And I remember him saying, what I'm teaching you here, I'm not 100% sure because they're going to amend the bankruptcy code and student loans, may impact those. They finally did amend it. It was like 5 years later. And then, I've been hearing the student loan debt's going to go away for the entirety of my career. I just haven't seen any significant changes. I think judges are dealing with it a little differently than they did in the past. But as far as the bankruptcy case on itself, I don't know. I don't know if that'll ever change completely. So, all right. This one, Charles says he won a case against Midland. Sounds like it was dismissed with prejudice. The debt was removed from all the credit reports. Now it's being reported again. Time to sue. The question I would have is why it was dismissed. If it's something where you went to trial and won, or if the court adjudicated it that you're not liable on this debt, then yes, I would say that they need to remove that from the credit report, because if a court has said you don't know it and now they're reporting it again, then you do have a claim, I think, both under the FDCPA and the Fair Credit Reporting Act. So that would be something to definitely look into. I would find an attorney locally. Both of those statutes have attorney's fees provisions. So attorneys are able to represent consumers on a contingency basis, meaning that they don't charge any legal fees up front to handle the case. They just take a portion of any collection that they get for you through that case. So I think that is that sounds like a fact pattern. Definitely you'd want to have somebody take a look at and help you determine if you have a case there. All right, this JJ, can you renegotiate a debt after you agree to a settlement payment plan? Everything's negotiable. The question is whether they're going to agree to it. So, I mean, if you're in a payment plan and you're actively paying it and you feel like, that maybe you could come in with something different, like a larger lump sum. I've seen clients do that where they're on paying a couple $100 a month, and they come into a little bit of money that they feel like they could just offer a lump sum. Sometimes we'll reach out and try to negotiate it that way. You got to be careful because you don't want to throw your current agreement into a bad situation. And obviously, I mean, if you're in a payment plan situation, they're not going to take something less, unless I guess you could show there's some kind of hardship. But you can, it doesn't hurt to offer that to see if it's possible. Kind of tough to do. Let's see this one. Showed up to my case and the lawyer did not even know it was happening, so it got dismissed. 3 months later, I get another summons. They have a different amount. They say, on 4 different pages. Stuff like that's kind of common. I don't see it as much in Arizona as I used to back in the old days, but the court dismissed it. I'd be interested to know if they dismissed it with or without prejudice. Sounds like they probably dismissed it without prejudice, meaning it could be filed again. But the fact that you see this sloppiness, because usually these complaints and a lot of the documents, they're simply mail merges. They're just plugging different names and different amounts in, and so you see that there are problems there. If the complaint itself is the one that has the problems, I can tell you often that is not the basis to getting the case thrown out. I mean, it can help because it shows, that there's some confusion even on their part, what, if anything, is owed on it. But usually if the complaint has a mistake in it, the court will allow the parties to amend the complaint to conform to the evidence. The place where it'd be a bigger issue is, like, particularly with debt buyer cases, when they submit an affidavit. I've seen that happen where the dollar amounts don't line up as far as what they're asserting there, because those are done under penalty of perjury. And the person who's giving the testimony is usually saying that they've reviewed the documents and they know that they're accurate. Anytime an affidavit is submitted, particularly by a debt buyer, go through it really carefully. I remember one of my favorites was the person whose name was at the top of the affidavit. Like it says, I, John Doe, testify to the following. They provide all the information. That name was different than the person who had signed it. So you can see there's some robo signing going on there, because clearly they didn't even pay attention of whose names was on. So we were able to get that case dismissed because of that. So, all right. Let's see what else we got here. I'll put this question up just because I get this quite a bit. You live in Iowa. Could you help me if I'm in a different state? I cannot represent people outside the state of Arizona. The way that it works with law practice is you must be licensed in that particular state to appear before the courts or really to provide any legal advice. So I can't do that. I do have some of my online video tutorials. They provide legal information. They're not state specific, but because a lot of the underlying principles are the same in these debt buying cases, I can provide information about those. But if you're looking for an attorney, a good place that I recommend you go is the National Association of Consumer Advocates. I believe the website is consumeradvocate.org, or it might be consumeradvocates.org. They have a search feature in there that allows you to search for attorneys based upon the state. And these are attorneys who do only this kind of consumer stuff. And you can even kind of pick the categories of attorneys that you want to look at it. That's a good place to go if you're looking for an attorney. But unfortunately, I'm not able to do that. I wish I could, but not able to, but appreciate that. All right. Let's look at this one. Just declared Chapter 7. My credit score has gone up 100 points after filing. Is this normal? Why are scores going up after something so bad? $150,000 in credit card debt was let go. It goes kind of to the point that I was saying, that the problem, or the benefit of the bankruptcy filing is that the formula that's used to calculate what your credit score is, you fundamentally change that by filing for bankruptcy and wiping out that debt. If your credit score is low, it's often because there's delinquent accounts and your credit cards are maxed out. Once you file the bankruptcy and you get that discharged, they're no longer maxed out. They're wiped out. They're showing a zero balance, and there's nothing that's delinquent anymore. So that algorithm that the credit reporting agencies use is just not there, and as far as to hold the score down. Now, obviously, the bankruptcy is showing up in the public records section, and that's going to influence some lending decisions. But the credit score itself rebounds fairly quickly. So it's kind of a myth of people who think, I'm not going to have any credit for 10 years if they file for bankruptcy. Simply not the case. Hey, JJ, thank you very much. I appreciate you supporting it, and glad we were able to answer some of your questions today. All right, let's look at this one here. Many of my bills and collections are from a divorce and an ex who doesn't want to pay his part. I paid mine every year, over thousands of dollars, or somehow in collections. This is a good question. It's something that comes up a lot in Arizona, because Arizona is a community property state. There's I believe 9 community property states, so it can be a little bit different. But I can tell you this: in many states, regardless of whose name the creditor, the credit card is in, or if it's in both of your names, and then you file for bankruptcy or divorce, if you file for divorce and the divorce decree says, okay, this spouse will take this and this spouse will take this debts, and they'll pay them off, that divorce decree is binding upon you and your ex-spouse. it's not binding upon your creditors. They didn't enter into that divorce decree, so they're not bound by it. So I see this routinely where married couple has a credit card together, and husband says, okay, I'll take this credit card, I'll pay it off, doesn't do it, then the wife gets sued. And then the wife's like, trying to raise the defense. Hey, he said he would pay this off in the credit, in the divorce decree. That is typically not a defense. But what it does do is most divorce decrees, what you ought to look and see if there's some what we call indemnification language or hold harmless language. Usually when there's a division of the debts of saying this spouse takes this spouse will take these debts, there's language in there that says, and will hold the other harmless from those creditors. So if I have an American Express card that I agree I'm going to pay, my wife and I get divorced, they come after her and she pays for it, there may be a remedy to go back to the family law court and ask for a judgment against me to have me reimburse any fees or any amounts that had to be paid. So it's a frustrating decision or situation with divorce decrees and debt, because the creditors, they don't care who they collect from, and the law generally allows them to do that. But you may have some recourse going through the family law court if you want to do that. Again, questions, different attorneys, consumeradvocates.org. Go check that out there. I don't have any affiliation with them. I'm actually not even an active member right now of ANACA, but I was for a number of years. I know a lot of the lawyers on there, and they're generally, they're focused on this for sure, and they're pretty good and overall. All right. Let's see if we got anything else. Let's see. Couple questions here. Can't give legal advice, but can you give general advice based on circumstance with the disclaimer, yet get paid for it? I generally don't. I appreciate that, but I generally don't. Just because you're going to be better served by an attorney in your particular state. I know there's not a lot of us out here that do this kind of thing. That's why I refer people over to that National Association of Consumer Advocates, just because they are lawyers that deal with these specific kind of cases. I mean, in the state of Arizona, there's 25,000 active lawyers, and I there's like a dozen of us that maybe do these kind of cases. So I know there's not a lot. There's not a lot of that. So, all right. I don't know if I've got all the questions here, but it looks like we got to a good portion of them tonight. Let me see if there's anything else. I think we got pretty much all of them tonight. I guess last call. Any other questions that everybody might have? But I think we got a good number of them done tonight. So, well, I appreciate you all tuning in each week. I enjoy these sessions every Thursday night. Looks like one more. We'll throw this one in. We'll have this one. Let's see. It says, is it different if there are any medical bills and he was ordered to pay a percentage of them? I paid my part, but he refuses to pay his. So this would be a case to take back to family court. Yes, that becomes a family court issue. Because again, the creditors are not bound by the divorce decree because they're not a party to it. The divorce decree is an agreement between you and the ex-spouse, and so they're not bound by it. So that's what the family court's going to be the best way to go there. There's one more showed up. From Texas, just received a writ of execution from a constable. What does that mean for me? A writ of execution is where usually there's a judgment that's already in place, and they're wanting to execute that judgment. They're wanting to take some type of property. Now, to my knowledge, Texas does not have any wage garnishment laws on the books. Which I've always thought's incredible. I don't know how creditors collect. That's how most collection is done in the state of Arizona. But a writ of execution is where they're taking the judgment and they're wanting to take property from you. Essentially, it's the mechanism for collection. Now, a writ of execution could be used for property. It could be used for vehicles. Could be used on a home in some states, other personal property. So the fact that you got that, you ought to look and see specifically what they're saying that they're trying to go after. There's kind of two writs of execution. There's a general writ of execution. Usually that's where they come by and they're just saying, we're going to take property that's not exempt. Often, though, it's usually a specific writ of execution where there's specific property. Maybe they're saying, "Hey, we think we can sell this car, or this boat, or something like that, to be able to get payment." So that's something for sure to have an attorney look at, because once it gets to that stage, they're getting aggressive. They're taking action on it, and something for sure is gonna happen soon. So you want to have someone take a look at that. Has COVID affected collections or lawsuits? Yeah, what's kind of interesting about that is you would think with this worldwide pandemic that you think bankruptcies would be sky high and the collections would kind of slow down a bit. They've actually increased. Bankruptcies have gone down dramatically. You've probably heard me talk about that on the channel. For bankruptcies, last year were at a 14-year low, which I think a lot of people were shocked to see, but it's because of a couple of things. One, there was a lot more money just in the economy than normal. Unemployment, for instance, unemployment in Arizona was $240 a week, and then with the federal increase, it added $600 per week more on top of it. And then there were the stimulus checks that came out. There were people who were getting, through their employers and things. So there's actually quite a bit of cash in the economy. And because of that, a lot of people were choosing not to file for bankruptcy. And not only that, but the debt collectors were aware of that. Now, initially, when the pandemic hit, there's companies like Encore Capital, which is the parent company to Midland Funding. They pumped the brakes a bit. Portfolio Recovery Associates, they said, they filed fewer lawsuits. But it was interesting. There was an article in the Wall Street Journal just a little while ago that Unifund, LVNV, Resurgent Capital, they're all the same company. They actually filed more lawsuits than they did in the years prior. They decided they were going full speed ahead with lawsuits. So you would think that COVID may have slowed some of these creditors down. They actually increased things quite significantly. So, all right, here's a question this is definitely a COVID question. Would you do Zoom court against a junk debt buyer as a pro se? A lot of courts are not giving you the option to come in. One defense that I always had in dealing with debt buyer lawsuits is I always wanted their witnesses to appear in person so we could go over the documents, and it was a lot easier. Issue with COVID is most of the courts are not allowing anybody to come in, but so that they don't get so far behind, they're starting to do things over the phone. They do things via Zoom. It's not as effective. It's harder to put forward the defenses, but there's not a lot of options right now. I actually had a trial yesterday in court. First time I've been in a courtroom in 15 months. And that's, I've been doing this for almost 20 years of being in court almost every day of the week. So it was kind of interesting to kind of be back, but it made me realize how much better that is when you're trying to cross-examine witnesses and go over documents. So unfortunately, you're probably not going to have much choice there. The court's going to be the one that's going to the court's going to be the one who's going to make that decision. All right, this one, intellectual property in my bankruptcy, including a trademark. I am an artist and the mark is tied directly to me. Do you think this will be part of the estate or be exempted? Good question. So to understand kind of this question, the background, when you file a Chapter 7 bankruptcy, we'll assume this is Chapter 7 bankruptcy, as soon as you file that, all of your assets become property, what's called the bankruptcy estate. Essentially, the trade-off is you're going to get rid of all of your unsecured debts, credit cards, medical bills, all those things are going to go away in the bankruptcy. The trade-off is if you have assets that are not protected by an exemption law in your estate, the court can seize them, sell them, and give the money to your creditors. So the question here is, this person, Anthony, has intellectual property in the form of a trademark. Is that going to be subject to the bankruptcy estate? It is part of the bankruptcy estate, but your question is a good one. Is it exempt? That I don't know. It depends on which state that you're in, because each state, there are federal exemptions, but most states have opted out and they only do, they have their own set of exemptions. And so, intellectual property like that, like in Arizona, would likely not be protected. And then the question becomes, what is the value of that particular asset? Because it's still something that a bankruptcy trustee has to try to liquidate. And so if it's something that intellectual property doesn't have any value, if you're not attached to it, it may be something that it's not a big deal anyway, and the court's not going to have any information or inclination to go after it because there's really no value there without you being part of it. So that's something definitely to talk to an attorney in your state. And that kind of goes to an underlying question, underlying issue with bankruptcy. Sometimes people think that bankruptcy is just filling out forms. And, a lot of people represent themselves in debt collection suits. And we talk about here. I don't usually recommend bankruptcy on your own. There are a lot of pitfalls. It could be a minefield, and there could be some serious consequences. I've seen people representing themselves in bankruptcy lose their home, lose their cars, and when they didn't need to. And so that's something to be really careful of if you're thinking of bankruptcy. My recommendation is at least meet with an attorney and get some information there. All right, let's see. A couple more questions. This question here, what makes a debt collector come after one person and not another? Unemployed. I can tell you one thing, they do make an evaluation of how collectible you are, but it's usually based upon records that are available to them. Credit reporting agencies like Equifax, TransUnion, Experian, if you go to their websites, sometimes people think that these are almost like they're part of the government because they feel that way. They feel like these kind of quasi-governmental institutions because they impact so much of our life. These are private companies who are there to make a profit off of information that's provided to them. And so what they do is they sell something called trigger reports. They sell these to debt buyers, debt collectors. Unifund is a big user of these, where they will look at information that's provided on the credit report, and they have an algorithm and a formula to determine how collectible you are. And not only that, they purchase these trigger reports, so when there's a change in circumstance in your life, it'll be such that they know that maybe this is a better time to go collect. I often get people say, oh, this came at the worst possible time. We're looking to buy a house, or I just bought a house, or we just bought a car, or I just changed jobs. It's not a coincidence. They're following that. They got a notification that there was some kind of change in circumstance on your credit report that their experience has shown allows them to, that you're in a better position to collect or pay, or that you're in a tough spot, like you're trying to close on a house. So unfortunately, that information that's being provided to the credit reports is being used against you. So I always say they're not your friend. I mean, you want to have good credit, but they're not your friend. They're going to use that information against you. So, hey, got to say real quick to Anthony. Thank you, Anthony, for supporting us today and for submitting the questions. So, all right. Let's see. I'll go back to Kate's question. I think this was about the Zoom. Will the affidavit person show up on Zoom? I would guess that they will, or over the phone, because usually that's how they want to appear anyway, is over the phone. So, and they're not going to have an excuse. The court's going to, if their witness, sorry, I'm losing my voice on tonight. If they show up without their witness, they're going to have a problem proving their case, and they don't have any excuse that the court's making or requiring everybody to appear via Zoom or over the phone. All right. And last thing, I'll bring this up with Anthony because this is a good follow-up. He says, I'm planning to submit a bid with the trustee to buy my intellectual property back. That's something that sometimes people don't realize too. Instead of losing an asset, it is possible usually to negotiate with the trustee where instead of them taking the asset, you essentially buy back your own stuff. We see this with vehicles quite a bit in Arizona. In Arizona, your exemption is $6,000 of equity in a vehicle. Well, let's say that your vehicle's paid off and it's worth $8,000. So $6,000 of it's protected, but $2,000 of it is non-exempt. Usually the trustee will say, look, let's make a deal. Instead of me taking the vehicle and selling it, why don't you make an offer to buy out that $2,000 of non-exempt equity? So we offer something like $1,500 and we can break it up into some payments. So it's possible for that for that to be a way to resolve it as well. So, all right. Those are all great questions tonight. I think we're going to cut it off there. Appreciate everybody checking in. Again, we're doing this every Thursday night. I'm doing it at 5:15 Pacific time. I know I've asked people to do it a little bit later, but eventually I've got to go home at night. So I'm going to do it right now at this time. So you can check in a little bit early. And I saw the chat. You can post questions, and we can address this and then watch it later. But appreciate you watching. If you haven't subscribed to the channel yet, I would appreciate you doing it. And we will